If you run a family law or estate planning firm with 2 to 10 attorneys, you've seen the headlines. Multiple judges sanctioning lawyers over the misuse of AI, and somewhere in the back of your head, you've decided that means AI isn't for your firm. And I want to show you why that's the wrong lesson. We market law firms for a living, and one of our clients spends 8 hours a year on this total. A marketing team at a firm we work with told me flat out, using AI is fraud. And here's the thing, this firm prosecutes fraud. So when they say it, they mean it. And they're not alone. Read the comments under any sanctions story and you'll find potential clients saying, if I found out my lawyer was using ChatGPT, I'd fire them so fast. And here's where I agree with them. About legal work, they're right. If an AI drafts a brief and nobody checks it, goes in front of a judge with made-up cases in it, that deserves sanctions. Someone hiring a lawyer to protect their kids or their freedom does not want a chatbot advising them, full stop. So if you've been hesitating, that's not you being behind, that's your judgment working. But here's what the headlines never tell you about what actually happens in those cases. Honestly, when I see these stories, I have to roll my eyes just a little bit. Not because the sanctions weren't deserved, they certainly were. And it's because the lesson everyone takes from them. Nobody in these cases got sanctioned for using AI. They got sanctioned for signing words that they never checked. That's a proofreading failure wearing an AI costume. You would get the same sanction for citing a book that you never opened. AI is a book that talks back. You still have to check the citations. They skipped due diligence and the AI took the headline. This is a legal malpractice story, not an AI story. And in every one of these cases, the judge's question is the same. Where did this come from? And the sanctioned attorneys couldn't answer it. I call that the provenance rule. Know where every word came from. Now here's the turn. That exact question is what makes AI marketing safe, if you build the system around answering it. Because here's what AI actually is and what the lawyers in the headlines got backwards. AI is not a source of knowledge. It's a presenter of your knowledge. You confirm the facts, it makes them presentable. So here's how we run it. We call it the closed book method. Most people use AI like an open book exam, except AI brings its own book. And sometimes the book is made up or what they call an AI hallucination. That's where the bogus citations come from. We run it closed book. We sit your attorneys down on camera, about 30 to 60 minutes each, and interview them about the questions their prospects actually ask. That footage becomes the only book allowed in the room. The AI uses only what the attorney said on camera. Nothing from outside it to draft the blogs, the videos, the website, all of it. If you didn't say it on camera, the AI can't say it either. It can't cite a bogus case because it was never allowed to go looking for cases. AI gets you about 80% of the way there. A person finishes the last 20. Every piece, no exceptions. That's checks and balances. So when the provenance question comes, the answer is always the same. From the attorney on camera, and we have the footage. Let me show you an example of a real firm, because I know theory only goes so far. This is Benoni and Company in Pennsylvania.
Benoni?
They cover various practice areas like bankruptcy, family law, estate planning, and business law. 30 minutes of filming per attorney fuels about 6 months of marketing material for the entire website. Across a year, that's roughly 8 hours of attorney time. And here's what came out of it. This is amazing. Over 1,500 qualified leads, 75,000 new website visitors. Best campaigns were about $49 per lead, and the top blog post ranking page 1 with over 8,000 views. They had to hire 3 new attorneys to handle the caseload. The lawyers in the headlines got sanctioned for filing words they never verified.
Benoni
doesn't have to approve their marketing content because there isn't a word in it they didn't say themselves. That's the provenance rule, running in a closed book environment. And so you know where we draw our own lines. My videos that use an AI twin get marked as AI on YouTube every time, okay? My 80/20 content doesn't, because by my own rule, the knowledge is entirely the humans. Nobody discloses that a paralegal formatted their newsletter. This is the same thing. 2 things you can do today, and screenshot this. Before any AI-assisted content publishes at your firm, question 1, does it cite anything specific? Like a law, a stat, a case, a deadline? Question 2, if the answer is yes, can you find that exact fact in a primary source? Not by asking AI to confirm itself, a primary source. Can't find it? That's the failure from the headlines. Caught before it costs you anything. And second, name a sign-off owner. One person, even a 3-person firm, owns the final check before anything goes live. And one quick flag, YouTube's AI labels and your state bar's advertising rules are 2 separate tracks. Content you set on camera and approved sits comfortably inside both, but check your state's bar rules. That's a 1-hour project, not a reason to opt out of AI. The firms sitting this out because of the headlines are handing an advantage to the firms that have built the checks and balances. The question was never, is AI safe? It's the judge's question. Do you know where every word came from? If your answer is from the attorney, on camera, and we have the footage, you'll never be the one making the news. The Benoni case study is linked in the description below. No form, no call, no email, no gate, just the link, and it works. Take a look, and if it's something your firm should have, just let us know.